When the partners in a partnership can't work together, a court can dissolve the partnership and sell its assets. But can some of the partners buy the assets and keep the business going? The court considered that question in Prentiss versus Sheffel. Donald Sheffel, Mortimer Iger, and Chris Prentiss made a verbal at-will partnership agreement to buy and operate a shopping center in Phoenix. Sheffel and Iger each owned 42.5% of the partnership, and Prentiss owned the remaining 15%. But their agreement didn't cover any details, such as the term of the partnership's existence, how the business would be supervised, how title to the property was to be held, or how management issues would be decided. Serious disputes quickly arose, causing the relationship among the partners to deteriorate. Eventually, Sheffel and Iger notified Prentiss that any further dealings should be through their attorney. The shopping center operated at a loss. Nevertheless, Prentiss didn't contribute $6,000, representing his share of the partnership's operating loss to the business. Eventually, Sheffel and Iger froze out or excluded Prentiss from partnership management, although Prentiss was never denied access to the shopping center or contact with the center's resident manager. Sheffel and Iger sued to dissolve the partnership, citing Prentiss's general dereliction of his partnership duties and particularly his failure to contribute his share of the operating loss. Sheffel and Iger sought to continue the partnership business and requested that Prentiss's interest in the partnership be ascertained. Prentiss counterclaimed, alleging he'd been wrongfully excluded from the partnership, seeking the appointment of a receiver and the winding up of the partnership. Prentiss further requested that Sheffel and Iger be prohibited from bidding on the partnership assets when the receiver sold them. The trial court held that an at-will partnership existed and had been dissolved when Sheffel and Iger froze out Prentiss. The court appointed a receiver until the property could be sold, but the court refused to prohibit Sheffel and Iger from bidding on the property. Sheffel and Iger submitted the highest bid when the property was sold. Prentiss appealed to the Arizona Court of Appeals.